Big news in the world of renting, the Renters' Rights Act 2025 is now law. This is the biggest shake-up to renting in England in over 30 years, and it will affect more than 11 million people. Tenants are gaining new protections, landlords face stricter rules, and notice periods are getting longer. But what does this actually mean in practice? How will it change your tenancy? And could it solve the problems in the rental market or actually create new ones? In this video, I'm going to break it all down, section by section, with examples and tips for tenants and landlords. Before we take a closer look, do me a favour and hit that subscribe button. Now let's get into it. Periodic tenancies, the new normal. Let's start with the basics. Fixed term tenancies, those 12 or 24 month rental contracts, are officially being scrapped. From now on, all tenancies will be periodic, rolling month to month. For tenants, this means greater flexibility. You want to move? Just give 2 months notice. No more being trapped in a substandard house for a year or more. For landlords, this creates uncertainty. If you rely on rental income to pay your mortgage, monthly rollovers reduce predictability. Here's an example. Imagine a young professional renting a 1-bedroom flat in London. They can now move for a new job without waiting for the lease to end. That's freedom. But landlords may need to adjust financial planning, especially small-scale landlords who rely on steady cash flow. This system already exists in Scotland, and early data shows tenants love it. But landlords responded by scrutinising tenant applications more closely, checking income, rental history and credit. It's a big change on both sides. The end of section 21, no fault evictions. Now, let's talk about the headline change. The end of section 21, also known as no fault evictions. Last year, more than 11,000 households were evicted by bailiffs under section 21. That ends with this new law. Landlords can no longer evict tenants without a valid reason. Instead, they'll have to use specific legal grounds. For example, serious rent arrears, property damage or antisocial behaviour, or if they plan to sell the property or move in themselves. Here's where it gets interesting. If the landlord is selling or moving in, they cannot serve notice during the first 12 months of the tenancy. And when they do, they'll need to give at least 4 months notice. For other situations like rent arrears or antisocial behaviour, the notice period will vary, depending on the circumstances. And the government is still setting the exact timelines for each type of case through secondary legislation. So in short, tenants gain real security. No one can just tell you to leave because they feel like it, but landlords can still recover possession if there's a genuine reason. And here's the flip side. Courts will now play a bigger role in deciding these cases. That could mean longer waits for landlords if the court system can't keep up. Example, a tenant reports damp or disrepair to their landlord. Before, that could trigger a no-fault eviction. Now, they're protected. The landlord must address the issue or rely on a specific ground. For landlords though, this means being cautious at the start of tenancies, checking affordability, rental history and references more thoroughly. So while tenants gain stronger rights, it's likely that the landlords will respond with stricter vetting and tighter screening processes. Decent Homes Standard and AWAB's law. This section could be genuinely life-changing for tenants. First, the Decent Homes Standard is coming to private rentals. Homes must meet a minimum health and safety standard, something that was previously only for social housing. Now legally requires landlords to fix serious hazards within a set time frame. For tenants, this is huge. If your home has mould, damp or unsafe wiring, you now have legal grounds to demand repairs quickly. For landlords, especially those with older properties, this may increase maintenance costs and require closer monitoring of property conditions. Example, a London flat with persistent mould must be treated promptly under AWAB's law. Previously, tenants risked retaliation for complaining. Now, there's legal backing. This is a long overdue change. The public health benefits could be enormous, especially in high demand cities where substandard housing has been a real issue for years. Rent increases and bidding wars. Moving on to rent increases, under the new law, landlords can only raise rent once a year and must give 2 months notice. Rises must reflect the market rate, and tenants can challenge expensive increases through a first-tier tribunal. Plus, bidding wars are banned. Landlords and letting agents cannot ask tenants to pay more than the advertised rent. This change is designed to cool competitive rental markets in cities like London and Manchester. Example, Previously, a tenant moving into a flat might be asked to bid £200 above the advertised rent. That stops now, giving tenants financial certainty. However, landlords argue this reduces flexibility and may discourage investment in high demand areas, particularly as costs like maintenance, insurance and mortgages continue to rise. Pets, deposits and advanced rent. Tenants now have the right to request a pet, and landlords cannot unreasonably refuse. Landlords can require pet insurance to cover potential damages though. Deposits largely remain the same, 5 weeks rent for most properties, 6 weeks if the annual rent exceeds 50k. Advance rent is capped at 1 month or 28 days for the shorter rental periods. This reduces the upfront financial burden for tenants but increases risk for landlords. Example, a couple moving with a dog can now rent a property more easily provided they have pet insurance. This balances tenant rights with landlord protection. Students' benefits and discrimination. For students, university-owned or purpose-built accommodation can give 2 weeks' notice for tenants to leave. Private student lets can regain possession before each academic year if proper notice is given. Importantly, it is now illegal to discriminate against tenants who receive benefits or have children. Landlords can still do affordability checks, but they cannot outright reject tenants based on these factors. Example, a student receiving housing benefits can now rent without fear of being turned away, while landlords still ensure tenants can pay rent. Reactions and potential issues. The Renters Reform Coalition, including Shelter and Generation Rent, called this a generational upgrade to renters' rights. Homeless charity St Mungo's said it's a tangible step towards safe, secure housing. Landlord groups like NALA have warned that landlords will now scrutinise tenants more carefully, and courts may struggle with the increase in possession claims and rent disputes. So, while tenants gain unprecedented rights, landlords may become more selective, potentially reducing available rental stock. This could solve old problems but create new challenges. Implementation timeline and next steps. The Renters' Right Act received royal assent in October 2025. The removal of Section 21 will be phased in to allow courts time to adapt. Tips for tenants: review your tenancy agreements, document repairs early and understand your rights. Tips for landlords: update policies, understand timelines for compliance and ensure all properties meet new standards. The Renters' Right Act 2025 is a milestone, reshaping the rental landscape for tenants and landlords alike. Enforcement and implementation will determine its success. Let me know in the comments. Are you excited about these changes or worried about unintended consequences? If you found this video useful, do me a favour, hit that like and subscribe button. I'll catch you on the next one.